Washington Journal continues.
At the table now is Bradley Shear, who is an attorney, to talk to us about social media and the workplace. And Mr. Shear, we found this piece recently in the New York Times that got our attention. The headline says, "Even if it enrages your boss, social net speech is protected." What are they talking about here?
Well, first, I want to say thanks for having me, Paul.
Sure.
In general, what they're saying is that employers really have to be careful when it comes to creating social media policies. They can't have a policy that's overly broad. They have to have a policy that's focused, because there's a lot of situations where employees have gotten fired for what they're saying online. So, for example, if an employee talks about something that they disparage their boss, obviously that's something, if you disparage your boss in the online world and in the offline world, that's basically treated the same way, and there's a good possibility you may get fired. However, if you're talking about working conditions, and you're talking with other members of the workforce about those working conditions, that type of speech may be protected.
There is a case out there, Hispanics United of Buffalo, that was the subject of a recent ruling by the NLRB. Can you explain that case and cases like it, and what's happening in the law here?
Sure. Well, right now what the NLRB is saying is that, hey, look, employers really need to have a better focus on what people are saying. They have to really understand, look, if you're going to create a policy, focus the policy and have it done in a manner that is very concrete. For example, if you're going to say that certain information, you shouldn't talk about certain confidential information, or you should be very careful with saying inappropriate comments online. If you have that in the policy, you might want to give an example. For instance, you might want to say, well, doing a harassing post or threatening violence. That obviously is something that you should not be doing online, an employee shouldn't be doing. However, it's talking about working conditions such as, hey, look, I'm working overtime, I'm very upset with this, and you're trying to get a feel for what your other coworkers are doing. That's something that can be protected. And what happened in that case was you had several employees who got together and made some posts online, and their posts were found to be concerted activity, and they were looking for mutual aid, meaning that they were trying to figure out what the best way to handle the situation. And in those types of instances, that's when the NLRB says, look, these types of situations are protected under the Act.
Many have likened postings at a place like Facebook to the water cooler in the office. Do you have a sense, Bradley Shear, what percentage of companies in the country even address this right now or have addressed it?
There's been several studies out there, and one of them I saw that said something to the effect about 50 to 60% of larger companies are addressing these types of issues and are creating policies. But as the NLRB has said recently, there are several companies that have policies that are overly broad. One example of a policy that the NLRB has said is a very good policy is Walmart's policy. And that's because the policy really focuses on if something is inappropriate, then it talks about if it's harassing or if it's a threat of violence. So the NLRB really likes to have policies that discuss specifically what are potential instances that may create some type of workplace issue.
Let me invite the viewers to phone in with their questions and comments for our guest, Bradley Shear. He is a graduate of the University of Baltimore Law School, currently runs his own company called ShearSocialMedia.com, and you might be interested in knowing he's the first private practice lawyer in the U.S. to work with a state government, in this case the state of Maryland, to draft social media law. What was that like?
It was a very fascinating experience. I've worked with legislators in Maryland, California, Delaware. I actually also personally worked with Congressman Engel's office. It was very interesting. He introduced legislation last year, and it was just, I met him at a alumni function, gave him my 30-second elevator pitch, and he introduced legislation. And it was very fascinating trying to work with legislators to create definitions of what personal accounts are online and exactly how to handle these issues. And since it's new and there wasn't any type of precedent in the law for what these things meant, we were blazing a new trail, and it was very fun to do it also.
Back to the idea of what folks can post at work, what's allowed and not allowed. The New York Times piece points out there's been a recent series of rulings and advisories by labor regulators have declared many such blanket restrictions on speech illegal. The NLRB says workers have a right to talk about work conditions freely and without fear of retribution, whether the discussion takes place at the office or on Facebook. The NLRB, how much power, how much strength does it have in this area? Can anybody overrule the NLRB?
Well, the bottom line is that the NLRB's rulings, they focus more on private employers. And so it's something where they're the first ones who are really tackling these issues. And since there really isn't much guidance in the law as far as court cases go, I think there's going to be other courts out there. There's going to be courts out there that actually look to the NLRB's rulings and look to what their guidance is for their own potential rulings, because obviously in the very near future there's going to be some things out there. I'll give you a perfect example of something that I find very troubling. There was a case down, I believe it was in Virginia, where several employees of a police department, they liked the Facebook page of an opponent of, I believe it was the police chief, and they were fired for allegedly liking the page, and it's gone into court, and so far the judge ruled that liking the page is not protected free speech. However, there's a lot of people out there, including myself, who believe that liking a page should be protected free speech. Facebook is out there, the ACLU is out there saying that this is a major First Amendment issue, and it should really be protected under the law.
Do states approach this issue in different ways?
There's several states out there that have passed laws that actually protect employers. I mean, protect employers and protect employees. Mm-hmm. The state laws out there really are beneficial to employers and employees, because what it says is that, look, an employer does not have the right to request that you turn over your social media credentials. However, on the flip side, if you're not allowed to access someone's personal social media credentials, then you don't have the liability, because with access comes responsibility. And in fact, the new Michigan law that was recently enacted several weeks ago, it actually gives a legal liability shield to both employers and to schools, because this is really going on also in the schools. It's a very troubling matter that's happening all over the country.
The text from a recent NLRB ruling, the NLRB says that employees shall have the right to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. That's the way they wrote it. First call for Bradley Shear as we weave our way through relatively new issue here, right, due to Facebook and other social media. Murdoch is calling from Christiansburg, Virginia, Democrat. Hi there.
You're right. This is new ground. I find the lack of protections for the average citizen of social media frightening. I don't utilize social media because I have very strong opinions about labor relations and employee rights, and I live in a right-to-work state, which is a growing phenomenon as well. And it's always been my understanding that in a right-to-work state like Virginia, where I live, you just talked about the case with the police department, which I'm familiar with. Personally, when I looked at that and I thought about the laws in Virginia, if they hadn't given a reason for dismissal, which in a right-to-work state or with right-to-work laws like we have, they don't have to give a reason for your dismissal. So they could have avoided the entire issue just by citing a more legal reason to dismiss these people and ignoring the real reason why they did it. As far as the social media goes, it's something I'm not going to utilize personally to try to voice my opinions until there is some sort of Bill of Rights that does protect me, or does at least define what I am or what I'm allowed to say or what I'm not allowed to say, or what I'm protected from if I do say something. These things are so unclear with all social media and with the internet, and so like I said, I hesitate to utilize it myself. When you work for an employer in Virginia and they come to you and say you work, like I once worked on a piece rate at 5 cents a foot for insulation, and my employer comes to me and says, we need to cut your pay by 1 cent per foot because the company at the time was posting record profits. So whatever reason they gave, I'm sure I ignored it and just stated my case that that's 20% of my pay.
Let me jump in there and get a response from Bradley Shear.
Well, you bring up some excellent points. I mean, the bottom line is that most jobs in this country are employment at will, meaning that you can be fired for just about any reason that doesn't violate public policies such as race, creed, national origin, or disability. And you bring up some excellent points about the fact that it to be very careful with what you say and do online. For example, I don't really post that much online. If you take a look at my social media credentials, besides blog posts, which I really don't get into too much of my personal issues. In fact, I don't even talk about personal issues. What I really do is just talk about the facts, and I don't say negative things about other people or voice my political opinions or things of that nature, because the bottom line is anything you post online may end up being utilized against you in either a court case or by your employer, or whether it's in a civil case, such as if you're getting divorced. So you have to be very careful with what you're doing online, and if it's something that you really don't want other people to know about, do not post.
He suggested a Bill of Rights before he gets involved in posting things. Realistic idea?
I think it's a very interesting idea. There's some things out there that discuss a Bill of Rights. I forget which congressman it was. I think it might be Congressman Issa. I think posted some type of Internet Bill of Rights, and I think it's a very good idea. However, trying to get everyone to agree what that should be it's always the devil's in the details. So it's something that maybe one day we'll have some type of Bill of Rights online, but in general, any activity that is not it's not acceptable offline and may get you fired offline will most likely get you fired if you do it online. So if you should not be saying negative things about your boss in the workplace offline, you shouldn't be saying them online, because you just never know who's going to be looking at the content.
Roy is calling from Madisonville, Kentucky now. Roy's a Republican. Good morning to you, sir.
Hey, good morning, sir. I just got a couple things to say this morning. Social media, I just want to know what y'all cover on social media. Do y'all, guns don't kill people. People kill people. We had somebody stab somebody the other day with scissors, and I went to the hospital a few weeks ago, and they didn't give me intensive care down here at this hospital. They sent me home with antibiotic shots, and they wouldn't do surgery on me down at this hospital. And then I go to work and turn around, they fire me because I got toothache, and they wouldn't do nothing for me. I had an oral surgeon here in town, and they still wouldn't do no surgery on me. And everybody wants to talk about Medicaid and everything else when you don't even get the medical treatment that you get. And then turn around, you got back deals going with the president trying to sell our airplanes, our Navy stuff to the Middle East.
Anything you want to respond to there?
I think you bring up some very excellent points. However, something that you might want to be aware of is the fact is that you might need to have there might need to be laws out there regarding if, for example, you brought up the NRA. For example, if you like the NRA's page, you might want to feel like your boss should not be able to see that if your boss has a different opinion. So the bottom line is state laws that protect people from having to turn over their social media credentials are very important.
Here's a Twitter question. Is there a case citation that an employer can't demand a social media password from somebody who works for them?
Well, there are a couple of cases out there. I don't have the case cite on me, but there's a case that's, I believe it was New Jersey. It had to deal with a restaurant, and it had to deal with the fact that some employees were utilizing, I believe it was either MySpace or another platform, to vent about their work. Well, an employer, I believe it was a manager at the restaurant, asked for access to the content, and they pushed one of their employees to give up the information, and then the employees sued, and the employees won. I believe it's a New Jersey case, and then there's also a case from the early 80s, and the case is focused on the Stored Communications Act. So there are a couple cases out there. There's not a lot that deals with social media protection. So that's why there really, in my opinion, needs to be state laws and also federal law to A, protect employees' privacy, and also B, protect employers and schools from legal liability, because there might be some people saying, look, schools and employers should have the legal duty to basically see what everyone's doing online. Well, the legal liability issues out there are just so tremendous, so that's why I think that you really want to protect the employees and also protect school students, their privacy, but also give a legal liability shield to employers and to schools, saying, look, they don't have the legal duty to have to look at this stuff because it's off-duty, and it's off-campus.
To the point of free speech, one viewer, again via Twitter, wants to know, where is the line between simply expressing your opinion and an active prejudicial attack against an institution or a person?
That's a very good question, and unfortunately, it comes down to, it's all fact-specific. Every situation is a little bit different. And so, in general, if you're going to be making comments online, you might want to have, that might not be popular, you might want to have an anonymous account. And that's one thing, the beauty about living in the United States. Unlike China, China requires all of their internet users to register their real names with the government. However, in the United States, because of our First Amendment, because of our long history of anonymity and free speech, we don't do that. So therefore, it really comes down to, it's fact-specific, but feel free to comment online, but use an anonymous name if you feel uncomfortable that someone might out you for your comments.
Our next call is from Ralph from New York. Is it Manoa, New York?
Yes, it's Manoa, New York. I'm a UAW member from upstate New York.
Okay.
And thank you for C-SPAN.
Sure.
I'd like to ask your guest, Mr. Scheer, you cited the NLRB ruling at the outset on Section 7, concerted activity and mutual aid protection. And I was going to ask your guest, and I'll hang up and listen to his comment, but my question is, how broad is this ruling? Because organizing, if workers organize a union, that's Section 7, concerted activity. For example, how broad is this ruling? For example, the Nissan workers in Tennessee are trying to form a union. If they talk on Facebook amongst each other, concerted activity, does this ruling protect them, and how broad was this ruling? Thank you very much.
Well, thank you for the question. It's a very good question. I don't want to speculate on how broad the ruling may be, because all of this stuff is really very new, and there may be nuances to every single case, and a lot of things hinge on certain facts. But the bottom line is, if you're basically doing something that is concerted activity and it's mutual aid, and the definitions of that are kind of flexible, then that most likely will be protected. However, you have to take a look at the facts of every single case, because every case may be slightly different. So therefore, that's why I can't give you a specific answer on whether or not something is protected or not.
The New York Times piece has a line I wanted to get you to react to. Some corporate officials in this area are saying the NLRB is intervening in social media in an effort to remain relevant as private sector unions dwindle in size and power. A lot of stories about that today, the size of unions. That particular comment, another comment from Randy Johnson at the Chamber of Commerce. The board is using new legal theories to expand its power in the workplace. It is causing concern and confusion. What do you think?
Well, I think it's an excellent question. It's very, very timely. I think it was on the cover of maybe the Wall Street Journal and New York Times today about the unions' powers. I think the bottom line is the NLRB is they're trying to take current law or old ways of thinking and meshing it with new technologies. And granted, it's tough at first trying to figure out how does these new technologies apply to old types of laws. And obviously, since everything is very new, I think it's very important for the NLRB to really get it right. And obviously, I think it would be very productive if there was more conversations with the Chamber of Commerce and other stakeholders to really inform them as far as what exactly the NLRB is thinking about doing. And I think the NLRB is doing the best that it can by the rulings it's putting out, and they've also put out some other papers that try to give some examples as far as what is an accepted social media policy and what is not. So I think it really does help that I think the NLRB is trying to create policy and trying to create, I don't want to speculate on whether or not they're doing this to stay relevant, but I think they're just trying to keep up with the times.
By the way, there's a headline, Washington Times, union membership in this country at lowest point since 1930s. Decline comes as labor community loses ground in right to work battle. That's the way the Washington Times put it. Gary is on the line now from Point Pleasant, West Virginia, independent caller for Bradley Scheer. Good morning.
Good morning. My comments are about whistleblowers in the workplace and in general. Whistleblowers today are being prosecuted, or persecuted, by the administration, and the industrial military complex is just one of the tip of the iceberg for Bradley Manning. Today in the workplace, you have nothing to say about anything. And it's I was a 42-year Teamster, and believe me, I was fired from my job after 27 years because I was basically a troublemaker because I pre-tripped my unit, and it took too much time, and the company just couldn't tolerate this because it was an influence on the other workers. So after 27 years and 4 notices of discharge, I was thrown out with the garbage. And I'm telling you, whistleblowers today are the only, and it's through the Internet, this Aaron Schwartz, who just hung himself because he had a problem with being judicially persecuted for a very minor infraction on the Internet. This whole country is really going down the tubes fast, and we're almost into a slave mentality. It's really crucial that we start protesting or doing something to eliminate this problem. Thank you. I'll listen on the radio.
Thank you, Gary. Mr. Scheer.
Well, I think you bring up some very interesting points. That's why, in my opinion, I think people really should have the right to make anonymous comments online. And obviously, someone who's a whistleblower, once you stick your neck out on something, it may create tremendous problems for the future. And that's why, in general, you really have to be very careful with what you say, whether it's in person or online. And it just goes to show you, even in this day and age, you really need to make sure that if you want something to really be private, don't tweet it out, don't put it on Facebook, and just make sure you know that the people who you're talking to you can trust.
Does the law or rulings by the NLRB and elsewhere differentiate between somebody posting something on their own time at home versus using company resources to make the posting?
That's a very good point. I mean, the rulings have basically said, look, if you're doing this on your own time and it's concerted activity and it's for mutual aid to help your fellow employees, then it should be protected. As far as whether or not something is protected, whether you do it on a company's, either their network or their computer or their iPhone, that's something that you just have to be very careful on, because there's a push in Congress to actually protect someone being able to access their email accounts, their personal email accounts on corporate computers in general. This is my best piece of advice. Do not access personal digital assets on your corporate computer or your corporate iPhone or any other type of corporate owned electronic device, because whatever you access on a company's own device, they may be able to have access to it.
This Twitter message turns the question the other way. Do companies have the right of privacy and protection the same way public or private people do?
It's a very interesting question. I mean, companies have the right to want to have their confidential information protected. So in their social media policies, it's very, and also in their regular employment policies, which the social media policy usually is a part of, there should be something in there that talks about protecting corporate confidential information, corporate trade secrets. So companies do have a right to protect their private information.
Schwartz Creek, Michigan, Democratic caller for Bradley Scheer, our guest here in Washington. What's your name, caller? Caller, you there? I think we lost that caller. Let's try Paula in Washington, D.C. Paula's an independent. Good morning.
Good morning, gentlemen. I had a question, and it's in reference to my sister who was recently released from employment within the school system here, and it was due to, the school says it was due to a post that she'd made on Facebook as she departed for vacation, saying, something like, well, I'm glad to get out of here and go on my way and leave those. I don't know exactly what she put, but something related to the folks that work behind. Nothing really derogatory. But they also mentioned the fact that she had posted a child's picture at the school on Facebook a few months ago, as isn't this cute, etc. And she was released, and I was just wondering what your opinion is. I know it's all over the place now on that release, and also my sister did tell me that other individuals that work there have posted students' pictures online as well. So she wasn't the first one to do that. And I'll take your comments offline. Thank you.
Thanks. Let's see if our guest has any insight on it.
Well, I'm sure she probably won't be also the last person to do it. I mean, in general, I don't recommend teachers posting photographs of their school students online unless they've gotten permission from the parents. And even then, it might be something that you might want to think twice about. In general, anything you post online may be utilized in any form or fashion. So that's why you have to be very careful. And I would really recommend if a teacher is going to be utilizing Facebook for the classroom, to really make sure that they have buy-in from all the parents and they get permission from all the parents of all the students. And there's certain rules that are laid out about what will be posted and the type of content that we put up there. But in general, I would not recommend interacting with students on Facebook or any other digital platform unless everyone knows what's going to be done.
To the Republican line now, Ridge, New York, where Betty is calling for Bradley Shear. Hey, Betty.
Hi, good morning. Good afternoon. I have one question, but first I'd like to make a comment. If you don't want anybody to know anything of your business or anything, why are you on the computer and putting that information on? I feel that if you're aware and you make your children aware and you watch them, and we don't have to say anything about the adults. Some of them, don't think twice about going on and putting personal information. So, in my opinion, they get what they deserve. But my question to the gentleman is, what if we didn't have any computers? And I remember when we didn't have any. We didn't have these problems.
That's a very good point.
I think Betty's done. Go ahead, sir.
Oh.
Yeah.
It's a very good point. I'm of the opinion that you have to take a look to see what people are doing. Things change over time. People now are communicating online in a fashion that no one imagined 3, 4, 5 years ago. And when I was little, obviously, we had a IBM PC Junior at the time, and I mean that's something that it was just people were utilizing computers for work stuff. Now a lot of people are utilizing an iPhone to post all sorts of personal things up there. It's something that it's a societal and a cultural shift in how people are expressing themselves, and because of that, people are now putting things up. And they have been doing it for some time that are inappropriate and may get themselves in trouble. So when you said that people deserve what they get when they put things up there, it's the reason why, in my belief, you really need to educate people on these issues, especially in the schools, and you really need to also educate employees and let them know specifically what the rules of the road are, and what's accepted behavior, what's not accepted behavior, and show them, look, these types of incidents may carry on with you for the rest of your life.
Remind us of who is leading the way in the business world, corporate America, in this area, in generating policies and helping folks to clarify things.
Well, Walmart put out a policy that the NLRB used as an example, as a positive example, and something that works well. But as far as other companies, I mean, there are a lot of companies out there. I mean, I personally advise a lot of companies on these issues, schools, professional sports entities, and the whole thing is trying to get it right, and it's hard. It really is.
There's a Twitter message really digging deep here from Simon McPherson. Do partners have to be aware of their other half's work policy? Basically, can employers sack employees for the tweets that partners put out?
You know what, that's an excellent question. I'll give you a good example. I believe it was the head of either MI5 or MI6 out in Great Britain. I believe it's now the former head. His wife posted some photographs, some family photographs of them out on a family trip. Well, you really can't be posting your photographs of the chief spy in the country, because you just never know who's going to be utilizing the content. I think we just had a big issue ourselves here a couple months ago with CIA Director Petraeus. That was more emails, but still, I mean, you have to be very careful with what you post online and whether or not you have to know what your partner is doing. It's just a good idea just to use discretion, and if you don't feel comfortable with the post, or your partner, or you think your partner may not feel comfortable with the post, don't put it up online.
Let's hear from Manhattan, Kansas now. It's Todd on the independent line for Bradley Shear. Good morning.
Hi, good morning. I have a question regarding the control of the social media. I know a few engineering companies that have time monitoring software for their employees on how much they use their social media. And also, a second part to this question is, could there be a separate department that handles the social media, such as PR or some other independent department within the company? Thank you.
Well, every company has a little different philosophy on how they want to handle social media. Sometimes it's a collaboration between the PR department, HR department, legal, and you really want to have everyone on board and have everyone understand what everyone is doing, so that way you have a good policy in place, and you also want to make sure that you get buy-in from your employees. Because if your employees don't understand what the rules of the road are, then they can't follow it. So companies really need to make sure that they talk with their employees about these issues, get buy-in from all the different departments that deal with this, and then educate. And when they think they've educated enough, educate their employees more. Because I think the biggest problem here is just a lack of understanding and education in this space.
We'll try to get a couple more calls in for our guest. He is Bradley Shear, an attorney. ShearSocialMedia.com is a place to go to learn more. What will folks see over there?
They'll see different posts on some things that are going on. For example, my last post from last week was about the Manti Te'o matter. I deal a lot in the sports world, and it talked about a Notre Dame football player who was what's called catfished, meaning someone utilized fake online personas to trick him into thinking that this fake person was a real person and became his girlfriend. So I also discussed the state laws out there that deal with privacy protection and things of that nature.
Want to let the audience know, too, we'll be heading over to the Hart Building on Capitol Hill in a few minutes for the confirmation hearing for Massachusetts Senator John Kerry, Democrat, to become the new Secretary of State. So the Senate Foreign Relations Committee will be holding this event. We'll have it live. Should start about 10 o'clock. We'll get you over there for the introductions. And Secretary of State, the current one, Secretary of State Clinton, will do the introduction of Senator Kerry, as Mr. Kerry has been chosen to replace her. The hearing is going to be chaired by Senator Robert Menendez. So just as soon as Secretary Clinton and Senator Kerry arrive, we'll go ahead and take you there live. In the meantime, another call for Bradley Shear now on this issue of social media and the workplace. Las Vegas, Bill, Republican. Hi. Bill, you there?
Hey, yes. How you doing?
There you are. I got you now. Go ahead.
Oh, great. Nice to talk to you guys. Hey, listen, I work on the Internet full-time, and I've been doing Internet marketing for 20 years, and I've seen the inception of social media. And actually, I think it's pretty disgusting the way the Internet is going right now. I mean, it's very easy. I mean, there's actually no way to enforce a law to basically judge somebody basically what's based on the Internet. I mean, people can take, your listeners need to understand one thing, that as soon as they post any photograph or they buy a computer, their home computer, their identity is immediately gone. I mean, I could take somebody's photograph, you could take somebody's photograph, make a social media account, go on Facebook, say whatever I want to say, and pretend I'm somebody else. There's no way to control this. And for an employer to judge someone on somebody's social media activity is absolutely just ridiculous. I mean, I know people that are in the entertainment business, and they get gigs based off Facebook likes, and those things are faked every day. People are taking social media way too seriously. Cyberbullying, all these things. We really need to get a handle on it. But for an employer to judge the work or the person's character, that just absolutely violates everything about the Constitution that our country stands for.
Let's hear from Bradley Shear.
I think you bring up some excellent points. I mean, the problem is that you have a lot of people out there that are taking pictures of others, creating fake accounts like what happened with the Notre Dame football player, and they're utilizing social media in a negative manner, in a way to hurt other people. Then you also have some other people that are literally going on Twitter and they're practicing what I call social media credential fraud. They're literally going out and they're trying to get as many followers as possible. They get a couple 100,000 followers or maybe 1 million, and then they do it by following a lot of people. Then they unfollow a lot of people to try to prove that they only had to follow a couple people to make themselves look like they had the same type of social media following as a movie star or as a professional athlete. So I mean, you have a lot of people that are doing fraudulent things online, and it's unfortunate, but that's what's going on. And the way the law is written in this day and age, it provides a wide amount of protection to the digital companies, because at the end of the day, it's very difficult for them to police what's going on online. And I mean, where do you draw the line? Do you really think it's a good idea to make the companies liable for everything that's going on online? I mean, if you did something like that, it may stifle innovation, and that's the last thing that we really need, especially in this type of economy.
San Antonio's on the line now. Miguel, Independent. Hi there.
Hi. Do you think Facebook had any effect on the election?
Let me ask Miguel, what do you think about the question you asked? Are you still there?
What do you really think?
What's your own answer to that question?
Well, I'm asking you the question.
Okay. Let's ask Bradley Shearer.
I think it really brings up a good point. I mean, literally since 2004, when Howard Dean first utilized the internet to really start fundraising, and then obviously in 2008 when President Obama utilized Facebook, he had some people from Facebook help him out. And then obviously this last election cycle, I think social media is another platform to be utilized, and I think every little bit helps. Whether it's social media, but at the end of the day, you have to go out there as a politician, shake hands, kiss babies, do the stump speeches. Just being online is not going to do it, and you have to utilize that in an entire conjunction as far as creating a uniform platform, and utilizing social media is just one of the ways to get to the voters.
Julius is with us from Massapequa, New York, Democrat. Good morning.
Yes, good morning, everybody. I know I'm a little bit older, so it's not that difficult for me, but I'm not on Twitter, Facebook, MySpace, any of that stuff. So you know what the good thing about that is? I don't have to worry that, something I may have posted or said and maybe get worried, wake up in the middle of the night and say, hey, I better go back and see I posted something early in the day when I was angry or excited or upset about. I don't have to worry about that because you know what? It's the old-fashioned way. I talk to people directly. Part of my job is talking to people directly, and I'm just very careful what I say. But I never got involved with Facebook or any of that social media, and I'm glad. Other than a quick Facebook to my cousin saying, good luck in school on your exam, it's like one sentence, that's it. But today you got to worry about that. You have to find another job. That could come back to haunt you. And, good or bad, it come back to haunt you. Things that are put into print are very hard to take back once it's put out there.
Final thought from our guest on where this area of the law is headed.
I think it's a very exciting part of the law to be in, and I really think that we're just literally at the cusp of a new and exciting world as far as which way we're going to go. But in my opinion, I really think that there's going to be more state laws out there that protect both employees and students along with schools and employers, because I think that's the best way to go. You can't just have laws that favor one side over the other. You need to have give and take, and I think that's the best way to handle this situation. So I think the bottom line is it's going to be an exciting place to be in, and I'm going to wait and see what happens.
Bradley Shearer is an attorney talking to us here about social media and the workplace. Thanks a lot for your time and your insight this morning.
Thanks for having me.
Appreciate all your calls. We'll be back tomorrow at 7 o'clock Eastern, as we are every day, with another edition of the Washington Journal. We take you over to the Hill now, where Senator John Kerry of Massachusetts is going to have his nomination hearing for Secretary of State. That is the senator's wife with her back to the camera there, Teresa Hines. And Senate Foreign Relations Committee is going to meet for a couple of hours here. They're going to hear first from the current Secretary of State, Hillary Clinton, to do the introductions. The chairman is Senator Bob Menendez. And if you miss any part of this hearing, you can watch it later at cspan.org, and we will show it again here on C-SPAN television at 8:30 p.m. Eastern Time tonight. So enjoy the rest of your day.